for this session. With me today is Iza Fazana as the assistant bailiff and Aina Najdah as the timekeeper. We will begin the round whenever you are ready, judges.
Good morning. Good morning, Council. You may start now.
The court is now in session. The panel of judges for this session is Miss Ain Zulaika, Mr. Hidri, and Mrs. Charlene Adrenchin. The appellants are represented by Lina Maisara and Ainin Sophia, I apologize. And the respondents are represented by Nur Aisha Soleha and Nur Amalin Husna. Counsels for the appellants and respondents are each allocated 40 minutes to represent their respective cases, which is inclusive of maximum of 5 minutes each for their rebuttals and rebuttals respectively. We will now invite the first oralists to begin their submissions.
Good morning. Before I begin, am I audible?
Yes, you are.
Much obliged. If it pleases the Honorable Court, my name is Lina Maisara and I appear before the court today with my learned counsel, Ms. Ainin Sophia, representing the appellant, Mrs. Amrita, daughter of Ramasamy in this matter. Representing the respondents, Ms. Nur Aisha Soleha as the senior counsel and Ms. Nur Amalin Husna as the junior counsel. Before I proceed, Your Honor, do you need summary of the present case?
Perhaps briefly, the summary of facts.
Much obliged, Your Honor. Your Honor, in the present case, the appellant felt numbness and further consulted the first respondent, a medical consultant of Nilai SMX Medical Center, which is the second respondent in this matter. So the first respondent had made assumption that the appellant's numbness is a secondary progressive multiple sclerosis. However, the first respondent did not inform and advise the appellant on the seriousness of the numbness. Therefore, the appellant did not take seriously on her numbness. And on 2018, the appellant had moved to Sandakan, and it is convenient for the appellant to consult with the first respondent. Therefore, she consulted with Dr. Hans, and in this matter, Your Honor, Dr. Hans had suspicion on the numbness happened, and it turns out that the appellant had a primary progressive multiple sclerosis. Shocked with the information, Your Honor, the appellant agreed on the treatment administered to her. However, the appellant's condition worsened and affected her life, which resulted that the appellant can no longer work because of her condition. She was also informed that she cannot be cured. Your Honor, devastated, the appellant brought this matter in the sessions court. Unfortunately, the respondent were not found liable. Therefore, Your Honor, this is where the present case come into existence. This is an appeal case from the decision of the learned trial judge in Sessions Court of Seremban. It is our submission that the learned trial judge has erred in his decision that there was no breach of duty on behalf of the first respondent, and the appellant has failed to prove the vicarious liability of the second respondent. We submit that this decision should be overturned. Your Honor, having done with the summary of the present case, there are two issues to be submitted by the appellant. Firstly, the failure to advise is amount to breach of the standard duty of medical consultant. And secondly, the second respondent is vicariously liable in protecting the appellant from harm or risk of injury. Your Honor, today I intend to deal with the first issue of appeal, and my learned co-counsel will deal with the remaining issue. Your Honor, it is submitted before the court that the first respondent is liable under the medical negligence on two grounds. Firstly, the first respondent had breached the standard duty of medical consultant, and there was sufficient causation between the failure to advise and the damage suffered by the appellant. And this ground, Your Honor, will be dealt accordingly. Your Honor, firstly, we submit before the court that the first respondent had breached the standard duty of medical consultant on 3 points. Firstly, the first respondent had failed to advise the appellant. Secondly, The first respondent had failed to verify the initial diagnosis of the appellant's condition, and lastly, he failed to refer the appellant to a specialist. Your Honor, if there is no further question, may I proceed with my submission? Much obliged. Your Honor, according to the case of Fu Fiona and Dr. Su Fuk Moon and another, which was decided in 2007, the Malaysian Federal Court had laid down that when a patient consults with a person possess special skills and knowledge in medical treatment, that person owes duty to the patient, and this duty includes the duty to diagnose, the duty to advise, and the duty to treat his patient. Your Honor, in the present case, the relationship between the first respondent and the appellant came into existence when the first respondent consulted the appellant in October 2017. Thus, Your Honor, the first respondent is indeed bear the duty of care to the appellant. It is come to the dispute, Your Honor, that the standard of care is different according to types of profession. In the present case, Your Honor, as an independent medical consultant, the standard of care practices by the first respondent is expected to possess knowledge and skills for medical treatment. Hence, Your Honor, we submit before the court that the first respondent has the duty of care and must exercise his duty according to the standard duty, including to diagnose and to advise the appellant. Your Honor, if there is no further question, may I proceed with my first point? Much obliged. Your Honor, the appellant submits that the first respondent had failed to advise and provide necessary information to the appellant. If I may assist the court in the case of Gurisha Taranjit Kaur and another, and Dr. Premita Damodaran and another, which was decided in 2020 in the Malaysian High Court, in this case, the doctor is bear with the duty to advise and provide necessary information to his patient. This is to assist the patient to make choice of her treatment. Your Honor, in the present case, the first respondent had failed to give any advice or any necessary information, despite having the knowledge that the numbness suffered by the appellant is a symptom of secondary progressive multiple sclerosis, and this further can be referred in the mood problem, page 1, paragraph 3. Therefore, Your Honor, having done with my first submission, if there is no further question, may I proceed with my second submission?
Sorry, Counsel, I do have a question. When you say your first point is that the doctor had failed to advise, what specifically are you alleging that the doctor had failed to advise?
Thank you for your concern, Your Honor. This will bring us to my second submission, which is the first respondent had failed to verify the initial diagnosis of the appellant's condition. This is because if the first respondent had verified the initial diagnosis, which is the secondary progressive multiple sclerosis, then he can advise and give necessary information upon the disease to the appellant.
Right, so you're saying that what he failed to do is actually to verify, right? So my question is there a distinction between the duty to advise and the duty to treat, which in this case you say is the duty to verify? Is there a distinction? Is there a difference between the legal test for duty to advise and the duty to treat?
Thank you for your concern, Your Honor. May I be given a moment?
Yes, of course.
If I may, Your Honor, duty to advise is to give necessary information as to the nature of the disease prior to the diagnosis given by the doctor to the patient. However, for duty to treat is where it involves the consent of the patient's consent to be given a treatment prior to the disease confirmed and had verified by the doctor. In the present case, Your Honor, the first respondent had the duty to advise on the reason that the first respondent had made assumption that the numbness suffered by the appellant is a secondary progressive multiple sclerosis disease, which this disease is a chronic disease. Therefore, necessary information must be provided when it comes to the nature of the disease itself, because without any necessary information on the regards of the disease itself to the appellant, then the appellant will not going to know that the seriousness of the disease and the damage that she might suffer from the disease.
Much obliged. Please proceed, Counsel.
Much obliged, Your Honor. Your Honor, next, the appellant submits that the first respondent had failed to verify the initial diagnosis of the appellant's condition. If I may bring the court's attention, in the case of San Markan, son of Ganapati and another, and Dato' Dr. Turai Singham and others, which was decided in 2012, where the Malaysian High Court held that the consultant physician has the duty to make a further investigation of the disease medical condition, and the failure to comply with this duty constitute to breach of the standard of care. Your Honor, in the present case, the first respondent had the knowledge that the numbness suffered by the appellant is a symptom of secondary progressive multiple sclerosis. That is the reason why the first respondent has suspected that the appellant may suffer from the disease. Take into consideration, Your Honor, this disease is a rare disease happen in the Asian descent, and this can be referred in the mood problem page 1, paragraph 4, last line. Which means that, Your Honor, in the present case, the first respondent had the knowledge about the rare disease and know that this disease is a chronic disease and must further further investigation must be conducted, because if there is no early treatment or verification to the diagnosis itself, it will worsen the condition of the appellant. Thus, Your Honor, we submit that the failure of the first respondent to make a further investigation to verify the assumption made by the first respondent has breached his standard duty of care.
Counsel, based on the fact of the case and the paragraph 9 of your submission, tell me whether appellant ought to have reasonably foreseen harm to herself if she did not delay taking the matter up to the doctor earlier, and also if she attended infrequently.
My apology, Your Honor, may you rephrase the question?
Based on the facts given, tell me whether appellant ought to have reasonably foreseen harm to herself if she did not delay taking the matter up to the doctor earlier, and also if she attended infrequently.
Thank you for your concern, Your Honor. The first respondent had ought to foresee the numbness is the damage will be. My apology. May I rephrase my statement? The first respondent is ought to foresee the consequences and the damage may suffered by the appellant when he made assumption on the secondary progressive multiple sclerosis. And furthermore, Your Honor, if I may refer to the mood problem, page 1, paragraph 2, where the appellant had felt the numbness 9 months before the consultation. And Your Honor, if I may submit to the court that the first respondent had failed to take into consideration the 9 months of numbness will lead to a chronic disease. If I may assist the court in the case of Reynard and Excused Cuisine Limited, which was decided in 2006, the doctor in charge, who is consultant neurologist, has stated that frequent numbness may be an indicator to a much severe disease. So in the present case, Your Honor, the failure of the first respondent to take into consideration that the appellant had felt the numbness 9 months prior to from the consultation, the first consultation, from the first consultation proves that the first respondent had neglected other material evidences that prove the appellant might have secondary progressive multiple sclerosis. Have I addressed your concern, Your Honor?
It's okay, Counsel, just proceed. Thank you.
Much obliged, Your Honor. Your Honor, the appellant also submits that the first respondent had failed to refer the appellant to a specialist. I would like to bring the court's attention in the case of Ahmad Takif Amza bin Ahmad Huzairi and Kuala Terengganu Specialist Hospital Sendirian Berhad and others, which was decided in 2021, where the Malaysian High Court held that the failure of the defendant to refer the plaintiff's condition to a specialist has resulted to worsen the plaintiff's condition. Your Honor, in the present case, the first respondent had come into his knowledge about the secondary progressive multiple sclerosis, but had not referred such condition to the specialist. Your Honor, as a medical consultant that is expected to possess knowledge and skills for medical treatment, the first respondent know that the secondary progressive multiple sclerosis is a chronic disease and must be referred to the specialist without delay. Your Honor, multiple sclerosis disease is a progressive disease, and without early treatment, it will worsen the multiple sclerosis patient condition. I would like to assist the court in the expert evidence provided by Professor Dr. Azran, whom a pathologist from Seremban Specialist Center. According to him, if there was no delay in referral, the appellant would have 40% chance of remission and also similar chance of survival for 10 years. Hence, Your Honor, we submit that the first respondent has the duty to refer the appellant to the specialist, taking into consideration the symptoms, which is the numbness and the knowledge possessed by the first respondent. Therefore, the failure to refer shows that the first respondent had indeed breached his duty of care.
Counsel, on that point, can I just ask you, I think I agree that we have a little bit of an issue with the doctor's delay in referral, but my question is one of causation. Do we have evidence before the court that this delay in referring the patient caused her condition after that? Is there any evidence before the court?
Thank you for your concern, Your Honor. May be given a moment.
Of course, but I'm also aware of time. If you're able to answer it later during the course of your submission, that's absolutely fine. If you want to take a time now, also it's okay.
Your Honor, if I may, this will bring us to our second submission, which is there was causation between the failure to advise and the damage suffered by the appellant. Your Honor, if I may assist the court in the case of Ahmad Takif Amza bin Ahmad Huzairi and Kuala Terengganu Specialist Hospital Sendirian Berhad and others, the Malaysian High Court learned judge held that the defendant had failed to advise the parents on the seriousness of the plaintiff's condition, in which resulted to worsen the plaintiff's condition. Your Honor, in the present case, by applying the Bartford test, had the first respondent advised the appellant of any future risks or consequences, or in fact, these are the nature of the disease that should be informed to the appellant prior to the diagnosis, the appellant can prevent herself from suffering damages, in which she can treat herself, being given choices of treatment to treat herself.
So, but for the advice, she could have taken action and would have avoided what she had suffered. Is that what you're saying?
Indeed, Your Honor.
All right, thank you.
Therefore, Your Honor, on behalf of the appellant, we submit before the court that the first appellant had breached his standard duty of care and there is clear sufficient cause of failure to advise and the damage suffered by the appellant. Your Honor, if there is no further question, that shall conclude my submission. The remaining submission shall be continued by my learned co-counsel. Thank you for your time and indulgence.
Good morning, Your Honor. Before we start our submission, am I audible?
Good morning. Yes, you are.
Thank you, Your Honor. May it please the court. My name is Ainin Sofia binti Azlaini. I appear as the junior counsel on behalf of my client, Mrs. Amrita. Your Honor, in response to the senior counsel, now we will be making on the second issue for this case. The second issue arises in this case is whether the second respondent is liable on the act of the first respondent as the second respondent is vicariously liable for the act of the first defendant. Your Honor, we will now turn to our submission. The appellant submits that the second respondent has special duty on the plaintiff under the doctrine of non-delegable duty of care. Your Honor, to assist the court in understanding the doctrine of non-delegable duty, the appellant defines the doctrine of non-delegable duty as a duty to ensure the work delegated to others is well taken care, whereby the person has power or control over that person. From the appellant's point of view, the second respondent has non-delegable duty, where it is under the second respondent's duty to ensure the work that has been appointed to the first respondent is conducted accordingly, despite of the first respondent being an independent consultant. Your Honor, to assist the court to have a better understanding in regards to this issue, I would like to bring the court attention in Dr. Kwok Chong Seng and another, and So Chang Ling and another appeal, which was decided in federal court in year 2017. In this case, the court found that the hospital has the authority to ensure the doctor who provide the service have necessary competence and expertise in doing the treatment. This is because due care should be exercised in the performance of the function by whoever is appointed to do so. Besides, in the case of Datuk Bandar Dewan Bandaraya Kuala Lumpur and Kok Peng and another, the defendant owed non-delegability of care in ensuring that a contractor exercised his duty appropriately. Your Honor, by implementing to this present case, despite of the first respondent's roles as an independent consultant who is not attached to the second respondent, the second respondent still cannot escape the liability to ensure that the service provided by the hospital is the safest and guaranteed services. This is because the treatment is conducted under the second respondent, and due to the negligence and misconduct made by the first respondent at the second respondent premise, the disease has developed into bladder cancer and brain damage suffered by the appellant. The liability to take care of the appellant cannot be solely passed to the first respondent, as the hospital also has its responsibility and control to ensure the duty is well provided by any person who has been appointed. Your Honor, if there is no further question, may I proceed with my submission?
Sorry, counsel. I think
Yes,
there was
Your
an
Honor.
issue raised by the respondent that this issue regarding non-delegable duty of care was not even pleaded. So can you reply on that? Can the court consider issue which is not raised in your pleading?
Thank you. Thank you, Your Honor. May you rephrase the words again? My apology, Your Honor. Can you rephrase your words
Sorry,
again?
because in civil litigation, if you want to raise any issue or introduce any facts or evidence, must be based on pleaded facts. So was the contention by the respondent that this issue was not raised in pleading? So my query is whether this issue can be considered by the court if it is not, it has not been raised in your pleading, or is it just an issue of law that it doesn't require to be pleaded?
My apology, Your Honor. I can't assist you on that matter.
I see. Okay, you may proceed.
Thank you, Your Honor. Your Honor, if we may assist the court in Woodland and Swimming Teachers Association and others, which was decided in Supreme Court in year 2014, the court held that the non-delegable duty shall include the duty of care and duty to ensure the care is well provided by the respondent. Furthermore, in Counties and State Transport Authority, which was decided in High Court of Appeal in year 1984, the court opined that the hospital had non-delegable duty to ensure the reasonable care and skill is taken by the person who have the responsibility to do so. To support this argument, we would like to assist the court in Roe and Minister of Health and another, which was decided in Queensland in year 1954. The hospital authorities is responsible for their staff, including anesthetists and the surgeons, despite whether the staff are permanent or temporary, resident or visiting, or full-time or part-time. Your Honor, in applying to this current case, the second respondent has duty to give reasonable care to the appellant, as the appellant has sought medical treatment in the hospital due to the disease. The second respondent also responsible in making sure that the treatment was conducted accordingly, as the second respondent has the power to monitor the works. Your Honor, this is also in line with the definition of private hospital under Section 2 of the Private Healthcare Facilities and Services Act 1998, where it defines private hospital as a premise to give treatment and care for those who suffer from any disease. To support this argument, in the case of Vincent Manikam, son of David, and others, and Dr. S. Hariraja and another, which was held in Court of Appeal in year 2018, the Honorable Judge found that the hospital or healthcare facility or service provider owes a duty to all the patients who attend or admitted to its care. By looking in our case, the appellant was in her vulnerable condition, whereby she had a substantial numbness in her left limbs and right leg. And for that reason, she needs to take the matter up with the first respondent, who works as an independent consultant at the second respondent, and thus had special dependence on the second respondent in giving its best services. Your Honor, if there is no further question, may I proceed with my submission? Much obliged. Hence, by referring to all circumstances, the second respondent had vicariously liable for the act of the first defendant under the doctrine of non-delegable duty of care.
So can I just pause you there for a bit? Your answer may actually be your submissions after this, and if it is, you just let me know. All right. You say that the hospital is liable through vicarious liability by virtue of NDD, non-delegable duty of care, right? Is vicarious liability and NDD, I'm just going to call it NDD lah, so shorter. Is vicarious liability and NDD the same as per in Kok Tung Sing? Was that the ratio of the federal court?
Thank you, Your Honor, for your consent, Your Honor. May you rephrase your word? My apology.
Sure, no worries. Don't apologize. Okay, when you talk about vicarious liability, well, what do you understand vicarious liability to be versus NDD? Are they the same thing? Are they one and the same? Are they referring to the same thing? That's essentially what I'm asking.
Thank you, Your Honor. Thank you for your concern, Your Honor. From my understanding, from what I've been read from the cases, vicarious liability happen when there is omission made by the other parties who is under the who is un, vicarious liability happen when the other party made mistake and the third party or the third party had to being liable on the mistake made by the second party. Okay, so in this case, we can see that the non-delegable duty is provided or is applicable as the second respondent is not attached to the hospital by referring to our mood problem clarification for mood problem, page 1, question 5, where it is stated that the first responder is not attached to the hospital. So by referring to our current case, we can see that even though the doctor itself has not have employer and employee relationship between the hospital, which is the third party in this case, but the third party in this case, which is the hospital, still liable because the hospital also has its duty to ensure that the service provided in its premise is provided accordingly.
So are you saying that for vicarious liability, I think you said it correctly, there has to be an employer-employee relationship or a relationship akin to that. That's what the federal court said, right?
Yes.
Are you saying that notwithstanding the fact that the doctor is an independent contractor, it is still a relationship that is akin to employer-employee because of the control? Is that what you're saying?
Thank you for your concern, Your Honor. By applying to this current case in regards to the non-delegable duty of care, we can see that even though there's no relation between the second parties and the third parties, but the third party still has liable or still has its responsibility in making sure that the service is well provided by referring to Woodland Tax, as we can see in the case of Woodland and Swimming Teachers Association and others.
Thank you, counsel. Please proceed.
Much obliged. Your Honor, according to the foregoing reasons, we will now submit our prayer for relief. The appellant respectfully requests this honorable court to adjudge and declare to set aside the session court's decision and hold the respondents are liable in negligence as there is sufficient causation between the failure to advise the risk of the bladder cancer and the brain damage suffered by the appellant. In addition to that, the appellant respectfully requests this honorable court to compensate the appellant for the special damages as she needs to incur a huge amount for her medical treatment and general damages as she lost of earning capacity. Your Honor, without further argument, I raise my case. Thank you for your time and indulgence.
Your Honor, before I begin, am I audible?
Yes.
Much obliged. Good morning, Your Honor. May it please this honorable court. My name is Nur Aisha Salehah binti Zainal Abidin, appearing as the senior counsel on behalf of our client, Dr. Kevin Lai and SMX Lai Medical Center. Appearing together with me today is my learned co-counsel, Nur Amalin Husna binti Muhammad Nazir. Your Honor, we wish to put forward 4 arguments. I will be dealing with the first and second issue within 18 minutes, and my learned co-counsel will the remaining submission for another 70 minutes. We will also reserve 5 minutes for the rebuttal session. Your Honor, before I proceed, do your Lordship need assistance on the fact of the case?
I think you just proceed your submission.
Much obliged. Your Honor, there are 4 issues to be submitted before this honorable court. First, the respondent does not breach his duty of care towards the appellant. Second, the appellant failed to exercise reasonable care for her health and contribute to her own damages. Third, there are no sufficient causations between respondent's actions and the injury of the appellant. And the last issue that we submit before this honorable court is Nilai SMX Medical Center does not have vicarious liability towards the appellant. Your Honor, as such, I will divide my first issue into 2 parts, which are, first, the treatment provided to the appellant had been given in accordance with standard of care. Second, Dr. Kevin is not liable for the delay in referring the diagnosis to the specialist. Your Honor, if there is no further question needed by the bench, may I proceed with the first issue?
Please proceed, Counsel.
Much obliged, Your Honor. Your Honor, for the first issue, we submit that the respondent does not breach his duty of care towards the appellant. Your Honor, if I may bring this honorable court's attention to the relevant cases that I will highlight throughout my submission. On the first ground, we submit that the treatment provided to the appellant had been given in accordance with standard of care. First, this High Court in Abdul Ghaffar bin Muhammad Ibrahim and Pengarah Hospital, Kepala Batas in another, decided that the act of the defendant is reasonable based on the standard of a reasonably competent or skilled person. Second, further discussion in regard to the standard of care for diagnosis or treatment can be seen in the volume test as expounded in the volume and Bryan Hospital Management Committee. Using the volume test, the majority of the House of Lords held that the doctor had not breached his duty of care because other reasonable doctor would have acted in the same way. Your Honor, we submit that under the first respondent's circumstances, he had performed his general and approved practice in the situation before him. He only has to conduct a reasonable standard of care and skill to treat his patient. Furthermore, all the CT scan had been conducted months after the consultation with the first respondent. There were no signs that the disease had spread to the other organs. This clearly shows that during the examination by Dr. Kevin, it cannot be diagnosed as a primary progressive multiple sclerosis as there are no other abnormalities. Hence, we submit that it is not compulsory for him to exercise the highest or very high standard as it was given within the acceptable standard of care, Your Honor. Your Honor, the second ground under this issue is we submit that the first respondent is not liable for the delay in referring the diagnosis to the specialist. If I may bring this honorable court's attention to the relevant provision and cases that I will highlight throughout my submission. Your Honor, first, Section 12 of the Medical Act 1971 stated that a person is entitled to be provisionally registered as a medical practitioner as he holds the qualification granted by institution of the second schedule. Second, according to the official circular letter by the Director General of Health Malaysia, Bill 3, 2002, the official title for the experts, the medical consultant, means a specialist or senior doctor who can practice independently in his field. Third, subjected to Part 2 of the Code of Professional Conduct 2019, the primary practitioner, who is the practitioner first seeing the patient, may manage the patient himself accordingly. Second, in the case of Dr. Chin Hyun Hiap versus Ng U Kun and others, the Court of Appeal held that the appellant, who is the medical consultant, was not negligent after considering that the standard of care expected of a medical practitioner. The judge further explained that a medical practitioner is not required to exercise a very high standard, but fair and reasonable as practiced by other practitioners at the same level. Your Honor, the last ground for my submission concerning the second sub-issue is submit that as for the first respondent, he may manage his patient according to his standard manner and qualifications that he had as a medical consultant.
Counsel, at this point, what was Dr. Kevin's specialty? You say her consultant is a specialist. What was his specialty?
Thank you, Your Honor. May I be given a moment?
Yeah, of course.
Thank you, Your Honor. Your Honor, if I may assist this court by referring to the mood problem clarifications, Dr. Kevin's medical expertise or job was left silent. However, referring to the mood problem, page 1, paragraph 2, Dr. Kevin was a surgeon and the independent medical consultant who is specialized or expert in MS. We argue that he is expert in MS as the appellant who, in the first place, suffered multiple sclerosis, primarily seeing the Dr. Kevin for further consultation on the multiple sclerosis and also to manage the multiple sclerosis surgery along with medication.
All right. Before that, before treating MS, right? What specialist would diagnose MS, or can any specialist diagnose multiple sclerosis?
Your Honor, thank you for pointing that out, Your Honor. May I be given a moment, Your Honor?
Of course.
Thank you, Your Honor.
Okay, maybe I just explain why I asked the question. Maybe it's easier that way. Because from my understanding, I think a neurologist is the person who can diagnose multiple sclerosis because it's got to do with your nerves, right? So was Dr. Kevin a neurologist or not? If he was not a neurologist, then my question to you is, why didn't he refer to the appropriate specialist? If you say he's a surgeon and not a neurologist, why didn't he refer the patient to a neurologist just to make sure that, you know, the diagnosis is confirmed and that she's given the proper treatment?
Thank you, Your Honor. Your Honor, thank you for pointing that out. If I may assist this honorable court by referring to the mood problem, page 1, paragraph 2, we argue and we submit that Dr. Kevin was a surgeon and independent medical consultant who is specialized or expert in MS. According to the British Medical Association, consultants are senior doctor or specialists that have complete full medical training in a specialist area of medicine and are listed on the General Medical Council. So we submitted that Dr. Kevin was specialized or expert in the area of MS, multiple sclerosis.
So if he was an expert in MS, you're saying that there was no need for him to confirm the diagnosis. Is that your position?
Your Honor, indeed. But however, the diagnosis when the appellant met with Dr. Kevin for having consultation and further investigation on her numbness, Dr. Kevin was confirmed that the diagnosis was made by Dr. Kevin is that the appellant had a secondary progressive multiple sclerosis at that time.
Proceed, counsel.
Thank you, Your Honor. Your Honor, we submit that the respondent does not breach on his duty of care towards the appellant. It is undeniable that the first respondent is supposed to establish a standard of care to his patient as a medical consultant. However, Your Honor, because the first respondent had carried out his responsibilities as a specialist by making diagnosis, treatment, consultation, and even surgery on Amrita, his acts are in line with the ordinary standards or other medical consultants or specialists. He has performed his obligations by informing the appellant about the risk of the disease and setting up appointments with her for additional treatment within 5 months. Therefore, we submit that he's not liable for the delay of the referral to another specialist because he could manage the patient himself as a certified medical consultant without making a referral to the second medical practitioner. We also submit, regardless of how chronic multiple sclerosis MS disease is, he already fulfilled his obligations and standard of care as a medical consultant, and he did not breach on his duty of care towards the appellant. Your Honor, having finished with the first issue, does this honorable court need any further clarification before I continue to submit on the second issue?
Counsel.
Yes, Your Honor.
So you were saying that the first respondent only has to conduct a reasonable standard of care and skill to treat his patient. Does this include that he had duty of care to advise the appellant in regards of the available options she has at that point, treatment, risk, and benefit?
Yes, Your Honor, indeed. We submit that Dr. Kevin already fulfilled his obligation and standard of care, including duty to advise, duty to treat, and duty to give a diagnosis.
You may proceed.
Thank you, Your Honor. Your Honor, having finished with the first issue, I will now move on to the second issue, which is the appellant failed to exercise reasonable care for her health and contribute to her own damages. I will divide my submission into two grounds, which are: first, the appellant did not seek for early treatment in regard with her illness. Second, the appellant does not continue the treatment with Dr. Kevin after 5 months the diagnosis had been done. Your Honor, if there is no further question needed by the bench, may I proceed with my submission?
Yes, please.
Yes.
Much
You may
obliged, Your
proceed.
Honor. First, by virtue of Section 12, Subsection 1 of the Civil Law Act, when a person suffers damage as a result of his own fault and the fault of another person, the damage recoverable in that case are reduced to the degree that the court considers just and equitable. Your Honor, on the first ground, we submit that the appellant did not seek for early treatment in regard with her illness. If I may bring this honorable court's attention to the relevant provisions that I will highlight throughout the submission. As can be seen in the case of Ahmad Takif Amsar, Ahmad Uzairi, and Kuala Terengganu Specialist Hospital, Sindar Berhad, and others, the learned judge further justified that the plaintiff parents' inability to bring the plaintiff to the hospital during the office hours is such as an unreasonable excuse. Second, based on the case of Jones and Liveworks Paris Limited, a person is guilty when he should have reasonably foreseen that if he did not take a reasonable action like a prudent man, he would like injured with his own action. In this instance, by the time that the symptom first appeared, it should have been a concern for the appellant to seek early treatment, and the MS symptom could be diagnosed and proper measure could be taken. She should foresee that the symptom of her illness, such as numbness, could possibly lead to more severe pain if she does not seek for early treatment for herself. Unfortunately, Your Honor, the appellant did not take any active step to seek for medical care within the 9th month prior to her first consultation with the first respondent when the symptom first occurred.
Councillor, I just have a question here. So you're saying the 9 months where she didn't see a doctor, it should be taken as contributory negligence. Is that what you're saying? Yeah. Did the respondents adduce any expert evidence to say that this delay of the 9 months had either caused or materially contributed to the damages which were suffered?
Thank you, Your Honor, for highlighting that matter. Your Honor, if I may assist this honorable court by referring to the mood problem, page number 2, paragraph 7, expert evidence provided by Professor Dr. Azran. There are a delay in referral in this present case. If there are no delay in referral, the appellant would have had remission chance of approximately 40% and similar chance of survival for 10 years. Because since the appellant had a delay for early treatment, her initial chance of remission have declined to around 25%.
Also, I have 2 questions. Number 1, whose expert was this? Prof.
Yes, Your Honor.
Dr. Azran. Prof. Dr. Azran, whose expert was that? Plaintiffs or defendants in the Sessions Court?
Prof, Your Honor, I cannot assist you on that matter.
No worries, that's fine because the evidence is uncontradicted anyway, right? But my second question, and very quickly, is this. So the expert says that the delay in referral is the cause of this reduction in the chance of remission from 40 to 25, correct? Now, interestingly enough, the appellants say that the delay in referral is Dr. Kevin's delay. Whereas the respondents are now saying the delay in referral is the 9 months which the patient delayed in getting medical treatment. So my question is to both counsel actually, the appellants and the respondents, anyone who can assist the court. What did the expert actually mean by delay in referral? Was it the delay on Dr. Kevin's part, or was it the delay on the patient's part? Anyone?
If I may assist the court.
Yes, of course.
By referring to the expert evidence by the Professor Dr. Azran, the referral is on the part of the first respondent, which is the Dr. Kevin. This is because by referring to the statement where it states that she would have had remission chance of approximately 40%. Remission is where the treatment is already given, meaning if the first respondent had diagnosed and verified and also made a referral to the specialist in order to verify the, may I rephrase my statement? If the first respondent had made a referral to the specialist, then the specialist can give appropriate treatment, appropriate advice to the appellant in order to get a chance of remission as what stated, approximately 40%.
Also, for the respondent, do you agree with that?
Your Honor, indeed, we agree. We agree that there are delay of referral, but we argue that the delay of referral was made by the appellant. However, Your Honor, we have another side of on the multiple sclerosis matter. There are a very few. Okay, if I may assist this honorable court to refer to National Organization for Rare Disorders by June Helper, secondary progressive MS speaking as RRMS. However, on the general of Society of the Multiple Sclerosis, people with an initial diagnosis of RRMS, 50% or more will develop secondary progressive MS to primary progressive MS within 10 years and 90% within 25 years. And also, according to headline media by Dr. Sharon Stoll, the multiple sclerosis is a chronic condition, which means it's long-lasting and there's no cure for it. However, according to Dr. Sharon Stoll, among 2.3 million people worldwide with diagnosed with MS, a very rare few cases may have complications so severe that their life is shortened.
I do apologize for cutting you here, counsel. The point being?
My point is that based on this fact regarding of multiple sclerosis, Amrita belongs to a very unique and rare cases in the community of MS because her MS disease developed at a very rapid rate in just 2 years from secondary progressive MS into primary progressive MS and later turned to the bladder cancer. And it is beyond the possibility of Dr. Kevin and even other doctors to as well to foresee such a unique cases of MS. Regardless of how chronic the disease is, Dr. Kevin already fulfilled its obligation, whether it is treatment, medication, as well as the surgery on Amrita to slow up the development of the disease.
Thank you, counsel.
Your Honor, may I proceed with my submission? Your Honor, may I be given an extension of time?
Yes, yes.
Thank you, Your Honor. Your Honor, as for second ground under this issue, we submit that the appellant does not continue the treatment with Dr. Kevin after 5 months the diagnosis had been done. The appellant should have continued the treatment, but she did not attend any treatment after 5-month consults with the first respondent. Moreover, when she followed her husband to Sandakan, it made it even more difficult for the first respondent to continue to keep in touch with the appellant or even arrange for further investigation or rehabilitation. Thus, we submit that the appellant's delay to seek for treatment had worsened the appellant's conditions and negligently contribute to her own damages. Hence, had the appellant continued receiving the treatment, her condition could be better. We submit that it is clear that it was not Dr. Kevin's fault in the first place. Your Honor, having finished with the second issue...
Sorry, counsel.
Yes, Your Honor.
Since you bring this issue of defense of contributory negligence and then the section 12 of the Civil Law Act, do you agree with me that this defense can only be used to mitigate the liability and not to negate the liability on the part of the respondent?
Yes, Your Honor. Indeed. The section 12. I'm sorry. My apology, Your Honor. May I begin a moment? Your Honor, the section 12, subsection 1 of the Civil Law Act, it is to determine when the contributory negligence, the damages recoverable in the contributory negligence cases to reduce the degree that the court considers just and equitable for the respondent if the respondent were liable on the medical negligence. My apology, Your Honor, but it is just an additional provisions that we bring to this honorable court.
So is that your alternative argument in the event that liability is established, then you may rely on contributory negligence to mitigate? Is that your position?
Your Honor, indeed. At the first place, we did not bring this court attentions that our client has liability on the part of medical negligence. However, this is just an additional provisions that we could argue if the courts make a decision that our client has medical negligence part of it. Your Honor, having finished with the second issue, does this honorable court need any further clarification?
Perhaps you can conclude your submission.
Much obliged, Your Honor. If there is no further assistance favored by this honorable court, that shall conclude my submission on the first and second issue. Thank you, Your Honor, for your time and indulgence.
Your Honor, may I begin? Much obliged. Good morning, Your Honor. May it please this honorable court. My name is Nur Amalin Husna, appearing as the junior counsel on behalf of the respondent. Your Honor, having finished with the first and second issues submitted by my co-counsel, I will now move on to the third and fourth issue, which are the no sufficient causation between the first respondent's action and the injury of the appellant. And the fourth one, SMX Nilai Medical Center does not have vicarious liability towards the appellant. Each of the issue will be submitted as a ground, which is the injury would still occur whether the first respondent treated the appellant or not. And for the fourth issue, the ground is there is no employer-employee relationship between SMX Nilai Medical Center and Dr. Kevin. Your Honor, if there is no further question needed by the bench, may I proceed with my submission? Much obliged. Your Honor, for the third issue, we submit that there are no sufficient causation between the first respondent's action and the injury of the appellant. Your Honor, I will submit the issue based on the ground that the injury would still occur whether the first respondent treated the appellant or not. If I may bring this court's attention to the relevant cases that I will highlight throughout my submission. The first case is in the case of Government of Malaysia and others and Jumat bin Mahmud. The federal court said that even if the appellant had provided sufficient supervision, still the injury would still occur. Therefore, the appellant was not liable due to the lack of causation between the first respondent's damage and the appellant's act. Further discussion can be seen in the case of Barnett and Chelsea Kensington Hospital Management Committee. The judge held that the defendants were not liable to the plaintiff because the husband's death was not caused by the negligence. Even if the husband had been treated by the defendants, he would still have died from the poisoning. Consequently, the doctor's negligence negligence was not cause of the defendant's death. Focusing on the injury, we submit that even with the treatment or no treatment, multiple sclerosis has no cure. Your Honor, in this instance, the chance of survival that declined to 25% is also not due to the action of the first respondent who did not refer the appellant to the specialist and not caused by the first respondent's act from the start, as the appellant's injury would still occur. If we may refer to the medical textbook, which is from Jackson and Powell of Professional Negligence, 4th edition, it was stated that if the chance that proper treatment would have secured the desired result was less than 50%, the plaintiff cannot prove on a balance of probabilities that the damage will not have occurred in any event. In this instant case, the remission chance is only approximately only 40% if she was referred. After considering whether the harm would have occurred if the respondent had acted that way, which is the referral, therefore, even with the referral, the injury would still occur because the chance is only approximately 40% at the first place.
Sorry, counsel, when you say the injury would still occur, what injury are you referring to?
The injury of the appellant, which is the primary progressive multiple sclerosis.
Right, so you're referring to the MS. Now,
Yes.
would you agree with me if I say that had Dr. Kevin administered more aggressive treatment earlier on, or had he confirmed the diagnosis of MS, her condition, which deteriorated very quickly, may have been different. Would you agree with that? Yes, I agree that MS is uncurable. You won't be able to remove it altogether, but the damage could have been minimized, if I could use that word. Would you agree with me?
Yes, indeed, Your Honor. But however, if we may refer to the article of medical from Dr. Sharon, he said that the medication of multiple sclerosis is only to help to reduce the chance of new development of new symptom. Therefore, still that the current symptom would still return at some point.
So it's likely that it might not have progressed to cancer if he had taken action earlier. You agree?
Yes, indeed, Your Honor.
Or then he should be held liable, right?
Your Honor. However, Your Honor, even if Dr. Kevin had treated the appellant, still the progressive of MS would still occur.
I agree,
because there is no cure.
but I'm just saying that he may have given her more years of life. That's what I'm saying. So because his inaction had shortened her life, if I could just put it very briefly, shouldn't he at least be accountable for that portion, for that particular part of it?
Indeed, Your Honor. However, even if the MS would still occur, yes, and then with the treatment from Dr. Kevin, it will help reducing the symptom of the MS, Your Honor.
Thank you, counsel. Please proceed.
Much obliged, Your Honor. As such, Your Honor, we submit that there are no sufficient causation between the first respondent action and the injury of the appellant, since the appellant injury would still occur whether the first respondent treated the appellant or not. Your Honor, having finished with the third issue, does this Honourable Court need any further clarification? Much obliged, Your Honor. If there is no further existence favoured by this Honourable Court, then I will continue with the fourth issue. Your Honor, for the fourth issue, we submit that SMX Nilai Medical Centre does not have vicarious liability towards the appellant. Your Honor, I will submit the fourth issue based on the ground that there is no employer-employee relationship between SMX Nilai Medical Centre and Dr. Kevin. If we may refer to the case of Dr. Kwok Chung Sang and another, and Su Changlin and another appeal, the federal court applied the first stage of the test in various claimants in order to determine the nature of the relationship between the hospital and the medical practitioner. The respected judge summarized that akin to employment are now included in the scope of vicarious liability in addition to employer-employee relationship. Multiple factors are to be taken into considering the stage, and the element of control on part of the hospital is no longer regarded as determinative. Hence, the court held that the relationship, in this case, the relationship between the hospital and the doctor was not sufficiently akin to employment for the hospital to be vicariously liable over the tortious act of the independent medical practitioner.
Counsel,
Yes, Your Honor.
tell me what is the basic rule of the vicarious liability?
Thank you, Your Honor, for pointing that out. According to the Dr. Kwok Chung Sang, in order to be vicarious liable, the nature of the relationship must be established first, which is employer-employee relationship, and then and the connection of the relationship with the act of the employee. Yes, Your Honor.
Okay, may proceed.
Much obliged, Your Honor. As in the case of Tan Eng Siu and another, and Dr. Jarjit Singh Sindhu and another, the independent medical consultant in this case, he has worked to the second respondent, which is the hospital, the private hospital. It was only an arrangement to use the second defendant's facilities. According to this case, the judge summarized that even when the hospital had proposed an instruction, the hospital has no control over the independent consultant. It is just a recommendation from the private hospital. If I may assist this court, according to the regulation of private healthcare facilities and service regulation 2006, regulation 395, sub-regulation D, a patient family must be under care of a registered medical practitioner who shall be responsible for the medical care service. Which means that the function of a private hospital in Malaysia is merely to provide hospital facilities and not the medical service, as medical service should be relied on the medical practitioner himself. Thus, the hospital has no right to control the doctor and give an order regarding the treatment, as the doctor is an independent practitioner. In other cases, which is Ki Boon Swan and others, and Adventist Hospital and Clinical Services and others, held that the hospital was not vicariously liable for the negligence of the doctors. The contract between the parties clearly showed that the respondents were independent contractors and not an agent or employees of the hospital. The learned judge also highlighted that the hospital was not liable under the doctrine of non-delegable duty of care because that issue was never pleaded and therefore should not have been considered. In this case, there was no causal link or causation proven by the appellant against the hospital. Your Honor, in the present case, it is clear that Dr. Kevin, in his contract with SMX Nilai Medical Center as an independent consultant, that free from any control or any interference or obstruction from the hospital management. As such, Your Honor, we submit that SMX Nilai Medical Center does not have a vicarious liability towards the appellant. Your Honor, having finished with the fourth issue, does this Honourable Court need any further clarification? Much obliged, Your Honor. In the light of submission made above, the respondent humbly requests this High Court to adjudge and declare that Dr. Kevin had performed duty of care towards Amrita according to the standard applicable in medical practice. And the second one, And the second one we submit to this court, Dr. Kevin does not have to make any referral to other specialists since he is a medical consultant himself. The third one, Amrita is liable for contributory negligence as she failed to exercise reasonable care of her own health. The fourth one, there is no special relationship akin to employment between Dr. Kevin and SMX Nilai Medical Center. And the last one, SMX Medical Center is not vicariously liable for the tortious act of the independent medical practitioner. If there is no further existing favor by this honorable court, that shall conclude my submission on the remaining issues. Thank you, Your Honor, for your time and indulgence.
It's rebuttal, right?
Good morning, Your Honor. Am I audible? Thank you, Your Honor. May it please the court. My name is Ainin Sofia binti Aslaini, and I represent the appellant, Mrs. Amrita. With the court's permission, we would like to reserve 5 minutes for rebuttal. Your Honor, we have 2 points of rebuttal to raise. Firstly, the senior counsel for the respondent focused the court's attention that the respondent has fulfilled the standard of care by conducting the treatment with reasonable care and skill. However, my learned friend omitted one very important point. Furthermore, the respondent contended that the first respondent has specialty on multiple sclerosis. Your Honor, by referring to our current case, the first respondent is not specialist of multiple sclerosis. If he is multiple sclerosis specialist, he would provide advice and necessary information on regards of the multiple sclerosis, as the specialist would know that the multiple sclerosis is a progressive disease. Hence, he possesses the knowledge that the numbness would lead to the secondary progressive multiple sclerosis. If the first respondent has advised Mrs. Amrita, she, as a reasonable person, can take necessary treatment to treat her condition. To add more, the disease is a rare disease, as mentioned in our mood problem paragraph 4, and it is under the first respondent duty to make further investigation and treatment. Your Honor, since the first respondent is not a specialist of multiple sclerosis, he has the duty to refer the appellant's condition to the specialist. If I may assist the court, this can be referred in the Code 1.2.1 of the Code of Professional Conduct 2019, whereby it states that in order to provide the best interest of the patient, the first respondent should have arranged consultation with multiple sclerosis specialists, as it is always better to suggest a second opinion in all doubtful or difficult or anxious cases. If the first respondent has acted according to the standard of care as medical consultant, the appellant probably has 40% of remission and will survive 10 years. Thus, we submit that the first respondent has breached his standard duty as a medical consultant. Secondly, the junior counsel for the respondent has stated that the second respondent does not vicariously liable on the act of the first respondent, as the first respondent as an independent medical consultant and lead to the absence of the employer-employee relation. Nevertheless, little did we know that in the case of Datuk Dewan Bandaraya Kuala Lumpur and Ong Kok Peng and another, although the task was under the control of the independent contractor, the employee was still not free from the responsibility of ensuring safety and health in the workplace. In this present case, the doctrine of non-delegable shall prevail, as the second respondent has power to control and ensure that the treatment is done accordingly. Your Honor, without further argument, I raise my case. Thank you for your time and indulgence.
Your Honor, before I begin, am I audible? Thank you, Your Honor. Your Honor, I have 4 quick points to make. First, the Learned Council submitted in their memorial page 2, paragraph number 7, that the first respondent did not give any advice or necessary information about the numbness may be symptom of secondary progressive MS as suspected by the first respondent. However, Your Honor, we submit that this is not the case. By referring to the case of this Honourable Court in Elizabeth Chu and the Government of Malaysia and another, the High Court has highlighted that a practitioner cannot be considered negligent if he follows the well-known rule. In the present case, Your Honor, the first respondent has arranged consultation with the appellant within 5 months, and it means we argue that all procedures, including diagnosis, advice, discussion on MS, disease, medication, and even surgery, are given according to the procedure as a qualified person in the field as stated in Word Problem, page 1, paragraph number 2. Second, the Learned Councils on their memorial page 1, paragraph 2 also assist this Honourable Court by referring to volume tests will be applied in order to determine the standard duty of care that the doctor owes. They further explain that in their memorial that the relationship between a doctor and the patient signifies the duty of care owned by the doctor, which includes the duty to diagnose, advise, and treat his patient. However, Your Honor, according to Fifina's case, the Federal Court held that the volume test has no relevance in determining the general standard of care as a medical practitioner in relation to duty to advise or disclosure of information and risk. Thus, applying the volume test generally to all cases for medical negligence would likely to lead to difficulties for patients to establish their cases. The volume test is still applicable, but only in issues pertaining to the duty of doctors to treat and diagnose and not covers all standard of care. Your Honor, third, the second feature of non-eligible duty of care is not present in this instance case. The Learned Council submitted on their memorial page at number 7 under their second issue that second respondent has special duty on the appellant under the doctrine of non-eligible duty of care. However, Your Honor, we submit that this is not the case. We submit that by referring to the mood problem, page number 3, the appellant appealed on 2 bases, which is finding that there were no breach of requisite standards demonstrated in Dr. Karim's action in delay of referral, and second basis is they appeal under vicarious liability. The Learned Council did not raise an issue on the non-eligible duty of care since these two are different doctrines. We also argued that the doctrine of non-eligible duty of care cannot come into existence when the employer-employee relationship between Dr. Karim and the Assam Medical Center are still uncertain. According to the case Dr. Koh Chong Seng, the feature of non-eligible duty of care was not satisfied since the hospital has never assumed a positive duty to protect the plaintiff from any injury. The judge held that the non-eligible duty of care is not imposed based on related vested interest, nor does it depend on the term of the relationship between the defendant and between the second respondent and the patient. In regards to the patient-hospital relationship, it was never been established due to the circumstances surrounding the plaintiff engagement of Dr. Koh and admission to the hospital. Your Honor, last points that I would like to highlight that the Learned Council on their submissions that the court shall use the but-for test. Your Honor, we submit that the but-for test of causation produced an all-for-nothing result. If the chance that proper treatment would have secured the desired result was less than 50%, the plaintiff cannot prove on a balance of probabilities that the damage will not have occurred in any event. Since the appellant remission in this present case, since the appellant remission chance was less than 50%, which is 40%, the balance of probabilities cannot be raised, Your Honor. Your Honor, if there is no further clarification needed by the bench, that shall conclude my rebuttals on behalf of the respondents. Thank you, Your Honor, for your time and indulgence.
The Honorable Court is now adjourned. Participants are required to exit this breakout room and enter the main room, so we can allow the judges to fill out the score sheets in this room. Please do not exit the window or click the leave meeting. You will be invited back after the judges are ready to give you the feedback session. Dear judges, you are now welcome to fill up the score sheets. If I may, I wish to remind you that the time allocated for this moment is 10 minutes. Please inform when you are done to filling the score sheets.